Mr. Chair. Minister, last week the Privacy Commissioner testified that this bill is lacking some key privacy safeguards, including inconsistent proportionality tests included in section 15.2, subsection 3, but not elsewhere in the bill. And there is no requirement for his office to be notified when the communications security establishment, when there's a cyber breach that threatens Canadians' private information. I find that these omissions from the bill concerning. So my first question is, will the officials provide in writing to this committee the reasons why the proportionality test is not included throughout the bill, but only in that one section? And then secondly, to the minister for today, do you believe that the Privacy Commissioner's concerns have merit, and should they be included in amendments to the bill?
Again, Mr. Lloyd, I did have a chance to speak to the Privacy Commissioner last week. I am aware of the concerns that he has identified. There are a number of safeguards in the bill that includes referral, reporting to both NCIRA and NCCOP, which report ultimately to Parliament, as you're aware. We've also taken a number of amendments that he has proposed in the previous iteration under Bill 26. There's, I believe, 2 or 3 of the proposed amendments were incorporated. For those that are outstanding, there is reference to the Privacy Act, compliance with the Privacy Act. So I believe we have taken a number of very important steps. I am, as I've always said, I'm open to discussions on potential changes.
We did have testimony at the same meeting from the Intelligence Commissioner, who receives reports from our intelligence community. We were told by officials that the information provided under C8 is going to be technical information, not private information. But the Intelligence Commissioner raised very concerning, saying that when he reviews these reports, the context that he's provided does include Canadians' personal information. So what is going to be done to ensure that when providing context to these technical reports, that Canadians' private information is not impacted or revealed?
Well, look, I think the role, I respect the role of the Intelligence Commissioner. Again, I also met with him last week, and I respect the work that he does. I mean, with respect, the issues of disclosure that are part of C8 is very much of a technical nature. It does not go into the privacy issues of individuals, and it should not impact necessarily the work of the Intelligence Commissioner. We've taken a number of safeguards, including reference to NCIRA and NCCOP, which are required to, there's an obligation for us to report any incidents to these agencies within 90 days of the incident.
Thank you, Minister. Sorry to cut you off. Who is the government required to report cyber incidents that impact the government of Canada itself?
I'm just going to maybe, if I could ask Colin to answer that question, Mr. Lloyd.
Thank you, Mr. Chair, for the question. So the answer is yes. The Government of Canada has a response plan known as the Federal Cyber Incident Response Plan. This is available online. As part of the requirement for that, should the federal government be subject to a cyber incident, it is to be reported into the Canadian Centre for Cybersecurity, the Treasury Board Secretariat, and Public Safety Canada.
Are those reports ever made public?
Of the specific incidents?
Yes.
Not to my knowledge.
Now, are you aware of incidents where Canadian government servers have been hacked for illicit crypto mining operations, costing the Canadian taxpayer millions of dollars?
Off the top of my head, no.
Minister, are you aware? I'm not. If there was an incident that there was illicit crypto mining on Canadian government servers that cost millions of dollars, would that not have to be reported in the public accounts as a loss?
I would assume it would be, Ms. Lloyd, yes.
And if it wasn't reported under the loss, why would be the reason why it wouldn't be reported?
I can't speculate, but if there's a specific incident, I will be more than glad to look at it and report back to this committee.
I'm just very concerned because part of this bill, there's secrecy provisions, and I'm concerned that there could be a lack of transparency because we know we're trying to hold, telecoms and others accountable when there's these cyber incidents, but who's holding the government accountable when they have cyber incidents that cost Canadian taxpayers millions and millions of dollars? And if the government doesn't report those incidents, we're potentially looking at Canadians not knowing the vulnerabilities in our government system. What do you say to that, Minister?
On a practical level, my understanding is that reporting does happen. on a case-by-case basis when incidents of cybersecurity that impact the privacy concerns of individuals. I do believe there's reporting that does occur.
Merci, député Lloyd, pour.
Thank you, Mr. Lloyd. Thank you. Thank you, Chair. Thank you, Minister, for being here with us today. Minister, your bill raises various questions and concerns among Canadians. I'm not judging as to its necessity. We'll see that during when it comes to a vote. But there is a certain level of concern. I have found that the Privacy Commissioner testified before the committee here last week and raised some concerns as to the transmission of information under 15.4. I think it was under Section 2 of the bill, which amends 15.4 of the Act, which says that the minister can require of any person that they provide, based on certain modalities, to the person designated or to himself or herself information regarding which there are reasonable grounds to believe that they're relevant, etc., etc. But the reasonable grounds are not described. It's just a general statement, whereas in the amendments for 15.23 of the Act, it says that the scope and content of the provisions under Sections 1 and 2, it says in the French version that they're reasonable. I think that's a poor translation. It should have been must be reasonable, because in English it says must. And so it should have been translated that way into French. In French it only says are reasonable. But assuming the correction is made, the provisions must be reasonable in terms of the seriousness of the threat. This protection does not exist under 15.4. I would like to know why and whether or not you're planning to make any amendments to adopt this.
With you in many committees where you have done an incredible amount of work to ensure the consistency in both official languages. So if there are errors or omissions, we'll be more than glad to look at. With respect to the reasonableness standard, it is one which has been defined by the Supreme Court, and there's a fair bit of clarity in terms of what that is. And for the purpose, I think, of the Act, it is a standard that was defined by the Supreme Court that clarifies the law on standard of review, provided guidance on the application of the reasonable standard. The primary case is Canada versus Vavilov, 2019, and it essentially outlines the test. And I don't want to go into the finer details of it, but that's the reference that I would provide to you, Mr.
Merci. Monsieur le Ministre,
Thank you.
À votre avis,
Minister,
les recommandations.
In your opinion, the Privacy Commissioner's recommendations should be carefully listened to and respected, or should we disregard them because they're not important?
I had the opportunity to meet with the Privacy Commissioner last week myself. I believe a number of the recommendations that they've put forward, there's 5 of them in total. I believe there's 2 or 3 of them that have been incorporated within the number of amendments that were adopted earlier.
Merci, Monsieur le Ministre. Mais ici,
Thank you, Minister. But here, we're talking about qualifying or outlining the definition of reasonableness. If it was useful under 15.2, shouldn't the same reasoning apply? I'm not the minister, you are, but in my humble opinion, it would seem that the same reasoning should apply to 15.4. Reasonable grounds, you know as well as I do, that the courts will interpret reasonableness in various ways, depending on which judge is, and for all kinds of good or not so good reasons. This is a variable criterion, whereas in 15.2, you seem to have clearly defined what reasonableness is, saying that it regards the seriousness of the threat. That seems understandable to me. We're talking about an exchange of information which would otherwise be confidential. Perhaps it is necessary, but what the Commissioner is telling us is that even if it's necessary, we have to be sure that this is not done in an undue fashion, because it has to represent a grave harm. It represents grave harm to freedom, individual freedom and liberties. Here we talk about reasonableness with respect to the seriousness of the threat. Again, I'm repeating my question, and apologies for doing so, but it's important to me. How come it's not in 15.4? Reasonable grounds to believe. I think that would be something easy to add regarding the seriousness of the threat, just as it's done under 15.2. Why not in 15.4? Now, maybe it's your intention to do so. I would invite you to do so if that's not the case. But if you're not doing it, why not? Why do you think that there's no use to doing it?
This is under advisement, but let me just comment that 15.2, the definition, I suspect is defined initially. 15.4 would follow the same definition, but I will be more than glad to look at it closely. If I do have follow-up, I will follow up with you directly.
Merci beaucoup, Monsieur le Ministre, j'apprécie.
Thank you very much, Minister. I appreciate that. Thank you.